The VAT collection by the Federal Inland Revenue System, that's the FIRS, on behalf of the federal government has been a subject of controversy in recent weeks. But with the recent order by the Court of Appeal in Abuja, which ordered both Rivers and Lagos to maintain status quo over the collection of value-added tax, what next should be expected? Joining me now to discuss this further is legal practitioner and tax expert Evan Tofili. Thank you very much for joining us on News Now. What do you make of this situation, especially since the issue of who owns the right to collect value-added tax might not go away soon?
Yeah, the ruling today by the Court of Appeal has granted stay of execution to the case in contention, because earlier on the Rivers State got judgment in its favor from the Federal High Court in Rivers. Okay, upon which they moved on to now enact their own VAT, the Rivers State, that is. Now, the position is that the FRS went to the same court to, ask for a stay of execution, was not granted, and now they have gone to the Court of Appeal, and now a motion to stay execution has been granted. What the implication of this is that both parties must maintain the status quo, which is that they must rest on the case pending the determination of the substantive suit in the case.
Now, it's quite clear that, from previous data that Lagos State and Rivers are one of the most producing states, or states basically, that contribute the most to the collective purse of the federal government. But we've seen other states, or do you think this situation, would, help other states, to produce more, to look inwards to ensure that situations like this do not rob them of any means of revenue?
The two states you just referred to are very huge commercially viable states. By structure, we know that Lagos became a crown colony in 1861. From that time to now, it became also the Federal Capital Territory at some point. And then it has a huge presence of commercial activities, companies, and the rest of it. So that is the advantage. Port Harcourt have the same semblance. But most other states don't really have that kind of capacity. Perhaps this will ginger them to look inward and then expand the tax net on their state so that they can earn more. But the argument that the state should collect this VAT is one that is stemmed from law, from the provision of the law, because the Constitution really did not grant the National Assembly or the federal government the powers to legislate on consumption tax, for which the VAT falls at. Okay, but the federal government is completely given the powers under the second schedule of the Constitution when you look at item 58 and 59, where it is specifically stated that capital gain tax and stamp duties are in the exclusive reserve of the federal government or the National Assembly to legislate on. So if you look at Section 4, Subsection 7 of the 1999 Constitution, the House of Assembly of the state is empowered by law to make laws for the good governance of the state. That is from where the states got the powers upon which they made their own VAT laws. Okay, but the larger implication of this is that we're going to have a lot of conflict in the future. Since the case is sub judice, we do not know what the Court of Appeal and subsequently the Supreme Court will say on the issue. But it's going to be a very long day on this tax issue, because the 2020 Finance Act increased VAT from 5% to 7.5%. And as of last year, the revenue collected from VAT constitutes 16.1% of our GDP. So it has become very attractive that there's huge revenue in VAT. And that is why states want to have exclusive reserve to that. But the states have forgotten that there's going to be input and output conflicts as time goes on. And then if they want to create their own tax regime law on value-added tax, it will mean that the federal government will also be collecting. And if the federal government collect, the federal government is going to collect so much because, I mean, the imports from the ports, from the airports, and all federal government installation and establishment, the federal government is going to work. So the state will get less. If you look at Section 40 of the VAT Act, it gives you a clear position on how the sharing formula works. That 15%, the federal government take 15%, the states get 50%, and the local government get 35%. But if the states succeed in pushing themselves forth that they have to collect, it means that 50% that they are getting, some of them are going to get less than that because the federal government will no longer collect 15%. If they are now left to collect, they'll be collecting up to 60% or thereabouts. So I hope that the state governors really understand the tax regime and then the larger implications of the agitations.
Indeed, Ms. Ofeli, but thank you so much for your contributions on News Now.